was the day that the Supreme Court was hearing arguments in this Rahimi case. The arguments have happened, and we're not really sure. You know, sometimes you can figure out which way the court is going to go based on how the justices ask questions. This is pretty amazing. The defendant in this case, a guy by the name of Zaki Rahimi, there's a great post about this over at Daily Kos that says, you know, he's something of a poster child for why Congress passed this law in 1994. In 2019, he assaulted his girlfriend in a parking lot. And then when he realized that there was a bystander nearby who saw him assault his girlfriend, he fired a gun at that witness, and then he threatened to shoot his girlfriend if she told anyone. 2 months later, so she went to the police. 2 months later, a Texas court granted her a protective order and suspended his gun license and warned him that possession of a gun while the order remained in effect is a federal felony. He repeatedly violated the court order. He threatened another woman with a gun. He fired a gun on 5 different occasions in 5 different locations. He fired a gun in a period of less than a month. Incidents ranged from shooting a gun repeatedly at another driver after a car crash to firing multiple shots in the air after a fast food restaurant declined his friend's credit card. So this, you know, trying to shoot your girlfriend, shooting somebody that gets in a car accident with you, shooting in the air in a fast food restaurant. You would think that any reasonable person knowing this guy's history would say, you know, maybe he shouldn't have a gun. But Clarence Thomas yesterday asked this question: how do we know that the defendant's conduct rendered him dangerous? You know, how do we know? Well, it could be that he keeps shooting at people, but he hasn't killed anybody yet. How do you know he's dangerous? Maybe he's just one of these guys with a big mouth and likes to shoot. Of course, you know, like I said, the big challenge is that the entire decision is going to be based on what the 5 or 6 Republicans on the Supreme Court can find that was said by people during the founding generation in the 1780s, 1790s about whether women should be protected from abuse by their husbands. And of course, there was not a single law in the books back then protecting women from violence by their husbands, because women were considered the property of their husbands right up until the years after the Civil War. Women couldn't sign a contract in the United States until the late 1800s, early 1900s. I mean, in 1972, Louise and I were married, and she wanted to get a credit card. She had to have she had to have my signature, her husband's signature, or her father's signature, or her older brother's signature, because you had to have a man sign. Right up until 1970, had to have a man sign a credit card application, or a mortgage application, or a car it's not a mortgage, car loan application. So somehow, I mean, it seems to me like the Supreme Court has kind of painted themselves into a corner. So, you know, yes, we're going to make these decisions based on what they said in the 1700s, but maybe we're not going to. I don't know. We'll see. We'll find out in 3 or 4 months.